Good morning, everyone. My name is Neil Smyth. I'm a partner at Mills and Reeve in our restructuring department, but I'm part of the organising committee for these webinars. So I am chairing today's session, which is on non-disclosure agreements, NDAs. The presentations today will be firstly by Mark Pearce, who is a partner in our intellectual property team and also heads up our national commercial team, and Simon Pedley, who is a partner in our litigation team, specialising in dealing with various corporate and commercial disputes, but also including disputes over NDAs themselves. Mark, if you could flick over to the next slide, thank you. Just some housekeeping. So I'll be chairing and I will be collating any questions you've got. We'll deal with those at the end. The webinar will last 45 minutes. Simon and Mark are down to speak for about 30 to 35 minutes, so we'll have more than enough time to deal with questions at the end. So please put questions in the Q&A box and we will pick those up at the end of the session. It would be helpful when you have a question if you could just indicate which slide or point it relates to the extent that that's relevant. So because we're obviously picking them up at the end, we can then cross-refer back to the relevant slide so we all know where we are. The session is being recorded. You should have heard that when you came on, but just so you're aware, and the recording and the slides will be available and sent out afterwards. At the end, there will be a feedback form. So please fill that in relation to your feedback on today's session, but also there is a section in that feedback form regarding topics which we are looking for next year. So if there is a topic that you particularly want us to talk about, then please let us know and we will look to arrange it as and when we can in 2022. So without further ado, I will pass over to the presenters just to give you some information on their agenda. Mark, if you could go to the next slide. So Mark will be talking on items 1 and 2. Around the law and NDAs and tips and drafting, Mark being more of a non-contentious lawyer. Simon will talk about the SRA, NDAs and documentation and information requests. In rough terms, Mark drafts them and Simon argues about them. But obviously in arguing about them, you get to know what works and what doesn't. So between them, they are the experts on NDAs. So without further ado, I will hand over to Mark to talk on the drafting side of things.
Thanks, Neil. I'm delighted that my colleagues think I'm the less contentious of the two of us, Simon. But there we go. And I do some litigation around NDAs historically. So NDAs frequently, I think, thought of as really simple documents, and at their heart, they really are. But actually, I'd have to say that the litigator in me has probably seen more disputes around bad NDAs than almost any other single contract concerning intellectual property rights or IP, because I think the fact that they are seen as so simple sometimes means they're rather taken for granted. So what I'm going to do first of all is talk a little bit about the framework, the legal framework that NDAs sit in, and why we use them, and then talk about drafting NDAs and some of the things to really look out for, and some tips about using confidential information as well. And then I'm going to pass over to Simon. So what is the legal framework in which NDAs sit in the United Kingdom? Well, UK law has 3 ways in which it provides for the protection of confidential information. The very new statutory limb of that comes from the Trade Secrets Enforcement Regulations, which brought into force the European Trade Secrets Directive. Before 2018, we didn't in the UK have any statutory protection for confidential information. Historically, though, confidential information has been protected for, I think it's fair to say, centuries by the law of equity, by common law. And obviously, contractual law can provide for parties to agree to obey obligations of confidence. So the regulations, as I say, enforce the Trade Secrets Directive. But generally, the accepted view in the UK is that actually the position they brought into force wasn't in any way substantially different from how common law had protected confidential information previously. It's worth noting there that there were European jurisdictions in which there were a very significant change where confidential information hadn't previously been protected. So what's the common law approach? Well, under common law, an actionable breach of confidence occurs when a party uses or discloses without the permission of a party to whom they owe a duty of confidence where the information is secret, so it's not in the public domain. It has the necessary quality of confidence. The courts refer to it, which really means it's got some value. The courts are not going to engage in protecting information which is of no value. And there must be an obligation of confidence. Disclosure must be under obligation of confidence, which the defendant owed the claimant. Now, that obligation of confidence can be an express obligation, or it can be an implied obligation. The circumstances of disclosure can be such that the recipient of information should have understood that the information was confidential. And it can be in writing, or it can be an oral obligation of confidence. And then under contract law, a party can agree in a contract that they will keep information confidential, and that can be a binding contractual obligation. And a claim for breach of common law obligation of confidence is an equitable claim, whereas obviously where you have a contract under which a party agrees to keep something as confidential, a claim for breach is a claim for a breach of contract. A contract may protect information which doesn't have that necessary quality that the common law requires, but any claim in respect of information which didn't have that necessary quality would I think almost inevitably be disproportionate. And it's worth noting that in most claims for breach of confidence, where there is a contractual obligation, there'll be a common law obligation as well, and a common law claim on top of the contractual claim. So that's the background in which NDA sits. So what is an NDA? Well, at its most basic, an NDA is that contract under which one party or each party agrees to treat information it receives as confidential, and that establishes a contractual obligation of confidence. It's also a record of the terms on which disclosure is being made, and that can be very important, as we'll see as I start to look at the terms. And it's the best possible evidence in a court that there is an obligation of confidence, making it almost impossible for the recipient of information to argue that there was no obligation arising. And that's really important, because where there isn't that proof of an obligation of confidence, one of the key factors or one of the key issues evidentially in a breach of confidence claim can often be whether there was an obligation of confidence. So if you've got an NDA, the defendant simply cannot argue that they weren't obliged to keep information confidential. So my first hot tip is do use NDAs or confidentiality provisions and other agreements, overarching contracts that you're dealing with whenever possible if you're disclosing confidential information, because they give you that proof, and they give you, to an extent, control over what the information can be used to do or how it can be used. So what are the common terms we see in non-disclosure agreements? Well, the first one to get right is to get the parties right. Who is disclosing the information? Who is the party that's going to want to enforce an obligation of confidence? Who's receiving it, and who is then going to be using it? And it's amazing how often actually you'll see NDAs between parties where, particularly where one of the parties in for instance, a collaboration agreement or proposed collaboration agreement is part of a group, it's the wrong group company that has signed up as a party to it. And then there's, again, that struggle to establish that the other company in the group that had the information was under that obligation. So get the parties right. And then what is the confidential information? Can you clearly describe it? Can you identify it clearly? You'll frequently see in NDAs that the obligation only applies to information that has been marked as confidential by the discloser. As a discloser, I tend to not like that sort of clause, because I don't trust, for instance, scientists when disclosing information to their counterparts at a party they're collaborating with, to always remember to put confidential on the piece of paper, or to send the email afterwards saying, you know, I told you that in that meeting, that's confidential. So avoid it if you can as a discloser, but does that restriction apply? And does it apply to any information disclosed before the NDA was signed? Very frequently you'll find situations where parties have been talking for a while and some information has been disclosed before somebody says we should have an NDA in place. And if that's the case, then you need to make sure that your NDA states that it applies to information disclosed before the date of the NDA as well as after the date of the NDA. And then importantly, but again, often this is a point that's missed, is it a one-way disclosure or two-way disclosures? Is it one party that's giving information to the other? And for instance, the potential acquisition of a business, is it the potential is it the business that's the target of the transaction that's disclosing information only, or is it, for instance, in a collaboration between two parties, mutual disclosure where information is going both ways? Make sure the agreement does that. I have seen a situation where a party wanted to run a non-disclosure agreement where they owed an obligation, but the party they were dealing with, it was a one-way agreement. And then this is a crucial one, and I think perhaps the thing that people get wrong or overlook most frequently in NDAs, the purpose. Commonly in an NDA, you'll see a definition of purpose, but actually what is really important is that an NDA sets out why the information is being disclosed and what the recipient of information can do with that information. Do think very carefully about what the purpose is. To explore collaboration is probably not specific enough. It's one of the most common areas for dispute. And don't think that a vague purpose is a good idea because it's easy to agree with the other side. I think it's really important to understand clearly what the purpose of the disclosure is and have that set out. And then use. What is it that a party can do with the information? And we'll come on a bit more to that. So then term, expiry and termination, and some of these can be quite difficult to agree. So the first thing is that there are probably a number of different terms during which things will happen in an NDA. During what period is information going to be disclosed? So are you talking about 6 months where parties are exchanging information to explore a collaboration, in which case it should say that. But then how long does the obligation of confidence last? It's very unlikely that at the end of that 6 months, the obligation should drop away. Do you have an obligation that is perpetual? Well, it can't be perpetual. It can only really be as long as the confidential information remains confidential. Or is there a set period of time where you can cap the period? Or do you want to say that it lasts for so long as any of the information remains confidential? And that's something to think about. And most parties, I think, prefer to have a long stop. 5 years is a number you see very frequently, but that can change. One of the first significant piece of litigation I got involved in when I started as a lawyer back in 1987 with a confidential information claim, where in 1992 a tribunal held that information that had been disclosed in 1959 remained confidential, despite being known by 98% of the industry under license from the licensor and the discloser. So confidential information can remain confidential for an extraordinarily long period of time. And what are the obligations on the recipient when the purpose is complete? When you've finished your negotiations, when you've explored your collaboration, when you've decided whether you're going to buy the target or not, what are the obligations then? Is there a continuing obligation of confidence? I think yes, there should be if the information remains of value. And what do you do with the information? Should it be returned? Does it need to be destroyed? Or is it neither or? Does there need to be a certificate signed by an officer of the recipient to say they've complied with that? It's a clause you often see. Not that frequently, but I see it, and it may be as a disclosure that it's a good way of making the recipient concentrate on whether they have actually complied with that obligation. Who else can the recipient disclose the information to? And that can mean internally as well. You can have an NDA. So if you disclose to a company, say you're disclosing to a company, then presumably that means they can disclose to anybody. But why not limit it to a set of employees who need to know the information for the purpose? Why not specify who those individuals are? Is there anybody else? Are there any agents? Are there any advisors? Can they show it to their lawyers? Can they show it to consultants? If so, let's specify that. So limits on who can see it. Do they, whether it's limited to people who need to know, whether you identify them individually, and how are they bound? If they're disclosing it to employees or to external agents, is it sufficient that they notify those parties of the obligation of confidence? Should they enter into an NDA with those further recipient? So should the recipient enter into a further NDA with the third parties they're disclosing it to on the same terms? Should you be able to rely on third-party rights? Or should there be a direct agreement between the disclosure and whichever third party the information is being passed on to? Or just a signed acknowledgement? Sometimes you see a requirement that third party signs a copy of a note saying they've had it explained to them. But important to make sure that disclosure doesn't go too far. The biggest problem with confidential information is it's ceasing to be confidential. The more people that know it, the more risk there is of that. So restricting disclosure and specifying that in the NDA is really important. And then I talked earlier about permitted use. Is it sufficient to say that it can be used for the purpose? And that, I suppose, is going to depend on how clearly and narrowly defined the purpose is. Or should the NDA specify what specific acts the recipient can do with the information for the purpose, or restrict other acts so they can't do it? Should they be obliged not, for instance, to decompile software? Should there be a restriction along those lines, or to reverse engineer, or to analyze materials? There should, I think, always be an obligation to keep the disclosed information separate, partly because the most likely way of information leaking accidentally rather than deliberately is because it gets commingled with other information and it gets lost track of at the recipient. And there should be a record of where copies are. I remember giving some training to the management team of a business in the process industry, it's a chemical company, where one of the senior scientists said, look, I'm working on 20 projects where we've got NDAs and they're all on my desk at the same time and I can't possibly keep them separate. That obligation can't really mean that, can it? Well, the answer is it does. And if you're disclosing information, you want it for that very reason, because he was effectively saying he was incapable of separating the information and not using one party's information for another party's project. And to me, as a discloser, that's not a satisfactory position. And should there be some sort of restriction on what can be done or what happens to information that the recipient develops from disclosed information? If they if analysis is allowed, should they be allowed to use that analysis beyond the purpose of the NDA or not? And then a little bit around boilerplate. And again, boilerplate's one of those things we think about as a little bit straightforward and don't tend to give much attention to, but don't ignore the boilerplate with NDAs. Don't ignore in particular jurisdiction clauses. It can be very easy just to settle on exclusive jurisdiction of the courts of England and Wales, but actually if your recipient is in France and there's a breach, you don't want exclusive jurisdiction of French courts because you probably want to make your application for injunctive relief in France because it's quicker. One of the things about, as I said, obviously, the key thing about confidential information is that it is confidential, and the danger with a breach of confidence is that information ceases to be confidential and becomes public knowledge. If you're concerned about a breach, you're going to want to act really quickly and stop further disclosure. That's going to mean interim injunctive relief, and it's going to mean moving really quickly. What you don't want to do if you've got to move really quickly is apply to the English courts for an interim injunction and then try and enforce that injunction in France or anywhere else. So I don't think in this case that exclusive jurisdiction clauses are necessarily what you want as a disclosure of information. You may have exclusive jurisdiction, save for the right to apply for injunctive relief elsewhere. Do think very carefully about governing law. I've set out at the start of my slides the background in which NDAs work under English law, but I mentioned that before the directive there were other European jurisdictions which didn't recognise the law of confidentiality in the same way that the English courts had done historically. And it remains the case that the treatment of confidentiality is different from jurisdiction to jurisdiction. So don't just assume that a neutral jurisdiction, a neutral governing law is going to give you the protection you want. You may find actually that different national laws treat confidentiality differently. So if you are in a position where you can't agree English law, then get some local advice on whether the agreement will give you the protection you think it's going to. Now, obviously, if you're doing lots of NDAs, and some businesses do lots of NDAs, what that means is you're probably going to want to have a number of safe havens, perhaps we'll call them, where you know that the local law works for you. But don't ignore either governing law or jurisdiction. And do consider, and I think I would recommend having one of those clauses that says that the parties acknowledge that damages may not be an adequate remedy and that interim injunctive relief may be appropriate in a case of breach. Because again, that should, in theory and in practice, will certainly help avoid the argument from a defendant that damage is an adequate remedy and that injunctive relief is not appropriate, or interim injunctive relief is not appropriate. Again, it should, I think, in most cases be obvious in a breach of confidence claim that interim injunctive relief is the only way of stopping the information losing its value by becoming public domain. But you don't necessarily want to spend a lot of time and money in court making that argument. So if you can put a clause in that gives you that protection, then why would you not do that? And then this is not so much about NDAs, but being the subject of an NDA as a recipient. Some tips, because clearly one of the problems you get, and actually I think the cases I've been involved in have been about 50-50 defendant and claimant, and in a number of those defendant cases the potential breach has occurred accidentally because these guidelines haven't been followed. So as a recipient, it's important to treat the obligation seriously. This is not just a document you sign so that you can get on with having the negotiations. It's a document that people need to understand. It is important to make sure that those in the organisation that get access to the information are aware of their obligations and aware of the importance of abiding by them, and aware of the need to make sure that anyone else they tell, for whatever reason, assuming it's justified reason, is also aware of those obligations. Do ensure that the information is kept separate. It needs to be in a separate folder on any server. It needs to be clearly identified. So keep records of who has got it and make sure they keep records of where it's stored. And again, that's relatively easy if it's kept in separate folders, either electronically or physically. And at the end of the purpose, when the agreement comes in, make sure that people do destroy or return copies of the information where appropriate. Make sure it's not sitting there on a server so that someone else can come across it and think, gosh, that's interesting, and then do something with it, because that's how claims start. As a disclosure, do ensure that you keep copies of NDAs. It sounds a really obvious thing to say, but I've been involved in a dispute where our client said, we know we've got an NDA with them, but we can't find it, because they entered into hundreds of NDAs a year and no one was keeping proper records. So do keep a copy of the NDAs, and do keep copies or records of disclosure. Do be able to say, we gave you this information on that date, and here's the email that did it, because for evidential purposes, that can be really important. And when disclosing information or further information, if there's repeated disclosure, do continue to remind the recipient of the obligation of confidence. Just, a line that says, pursuant to our NDA dated, here's this information, because it's important to make sure that the recipient remembers that they are obliged to treat it as confidential. And that is the end of what I was going to say on NDAs. I hope that's been interesting. I'm going to pass on to Simon, who is going to talk to us about the SRA's position on NDAs and recent developments there.
Thank you very much, Mark. Yes, good morning, everyone. The purpose of this section of the talk is to inform you, or hopefully just to remind you, that as regulated lawyers, there is a layer of obligation on us when dealing with these things beyond the law. So the SRA has done a warning notice. It was done in March 2018, updated in November 2020, about appropriate or inappropriate use of NDAs. And this all arose out of the Me Too movement and it concerns the practice, particularly of when settling sex abuse claims or whatever it might be, some organisations would try and gag those people with an NDA and make it a condition of their payout that they don't report it, go to anyone, talk about it, etc., etc. And our regulator, quite rightly, in my view, deplored that sort of behaviour. So that's the sort of context in which this kind of thing has arisen. I think it's fair to say that the the principles and so on that we're governed by, this was the position before, but it is now appropriately spelt out. So if you get these things wrong and get into regulatory hot water, you really have no one but yourself to blame. But we'll rattle through some of the issues. And we'll cover things very briefly that the SRA is concerned about your conduct when dealing with these things, not just the terms that go in the agreement. It applies whether your opponent is represented or unrepresented, though clearly when they're unrepresented, the duty is more acute. It applies whatever the context in which the NDA arises, though to be fair, it's much more going to be around contentious issues, employment, settlement agreements, things like that, rather than the purely commercial NDAs, which Mark has perhaps been focusing on. It gives some examples of behaviour it would find concerning. It gives examples of clauses it would find improper, and it stresses the importance of plain English. So we'll cover these things very briefly. So Mark, if you could turn us on to the next slide, please. This is a particularly acute issue where it arose for me recently, and it's highlighted the importance of this. We were dealing with a corporate client and a former employee of that corporate client who had been sued by another former employee for defamation and malicious falsehood arising out of a disciplinary process. And it's fair to say the relations between the parties were extremely bad. So the former employee who was bringing this claim had also brought every other sort of claim under the sun, lots of subject access claims, had brought employment tribunal claims, had reported the client to the ICO. This woman's husband was also assisting her in this vendetta, so he was reporting these corporate clients to their regulator, reported the individual employee to his new employer at university and suggesting that his qualifications had been achieved by plagiarism, and also this was a happy day, reported me to the SRA for a settlement agreement we were trying to enter into. And what we were trying to do was, as much as possible, when seeing if we could reach settlement, draw a line under everything and make it clear that these people would stop this vendetta, while making it clear that we weren't seeking to restrict them from, reporting criminal activity or anything like that. So these issues were very much live in my mind at that stage. Spoiler alert, the SRA found there was nothing further to do when it looked at our behaviour, which was, we knew was the case, but it was always a relief when these things come in. So this warning notice that we have, it makes it clear it's also about, it's any form of agreement or contract in which it is agreed that certain information will be kept confidential. So exactly what Mark was talking about. It includes clauses in wider contracts. If you try and tuck something away in a contract, these obligations still apply to you. It applies in whatever context. It applies to your conduct. And it does specifically apply to you as in-house lawyers, as well as to lawyers like us in private practice. If you turn us on to the next slide, please, Mark. The SRA does recognise that NDAs are perfectly legitimate things to be used, often to both parties' benefit, but they do make this point. We are concerned to ensure that NDAs are not used to prevent reporting to us, other regulators and law enforcement agencies, or making disclosures which are protected by law. We are also concerned to ensure that those we regulate do not take unfair advantage of the other party when dealing with NDAs. And they go on to set out a reminder of these key issues and risks for us to be aware of. So if you can turn to the next slide, please, Mark. The warning notice reminds us all of the relevant principles that we are governed by, and the key ones which they point out relevant to this context. Principle 1, we've got to act in a way that upholds the constitutional principle of the rule of law and the proper administration of justice. The principle that we must act in a way that upholds public trust and confidence in the legal profession, our duty to act with independence, our duty to act with integrity. So that's the overarching principles. It then goes on to talk about the standards and regulations and the more sort of specific things in the code of conduct, and it specifically refers you to some of these. So there are provisions there which prevent us from abusing our position by taking unfair advantage of clients or others. We have a duty to cooperate with the SRA, other regulators, ombudsmen, and those bodies with a role overseeing and supervising the delivery of or investigating concerns in relation to legal services. So we've got to deal properly with our regulator. We must not attempt to prevent anyone from providing information to the SRA or any other body exercising regulatory control in the public interest. We have a positive duty to report to the SRA promptly or the appropriate regulator any facts or matters which we reasonably believe amount to a breach of this serious breach of our regulatory requirements. And yeah, there are links in the guidance to all this stuff, and you can easily find it online. So, but it spells it out for you. And as in my case, a tenacious and agitated, determined opponent, even if acting maliciously, they will report you. It can happen. So believe you me, it is always better to deal with these things properly, so that if your regulator does look over your shoulder, you could be satisfied that you are not going to be chastised for your behaviour. And it can be difficult, and I think this might be particularly acute for you as in-house lawyers, where you're employed by your client. What if you're being put under pressure by your client to behave in a way which is contrary to these things? I don't have an answer to that other than to sympathise with you for the position you find yourself in, but that is the position you are in, so bear that in mind. And the SRA expectations make it clear that if you get this wrong, this is a potential disciplinary matter. You are at risk of disciplinary action, and your duty to act in your client's best interest does not override your wider obligations to uphold the administration of justice and so on and so forth. So if you could turn to the next slide, please, Mark, we'll look at improper use of NDAs. Let's just check how we're doing on time. So I won't go at any great length. It's set out there, but these are examples of the sorts of things which the SRA would regard to be an improper use of an NDA. So seeking to prevent someone making regulatory or criminal complaints, seeking to prevent whistleblowing, seeking to influence the substance of any whistleblowing, etc., that does take place, attempting to stop disclosure of the NDA or the information to professional advisors, including clauses are unenforceable, trying to take advantage of someone, using warranties, indemnities, or clawback in a way to inhibit permitted disclosure. So, for example, if you said, you must give a warranty that you will not report us to the SRA, and if you do, you'll pay your 50 grand settlement figure back. Well, that will be a complete no-no. And there's a sort of wider point they make as well, which is you mustn't seek in any such agreement to give the impression that they're prohibited from these things, even if legally they're not, and the drafting doesn't actually say it. So basically, don't be all cutesy with the drafting. You've got to be clear, use plain English and clear what is and isn't permitted. So don't try and bamboozle them into thinking they're prohibited when in fact they're not, because that would be a regulatory offence as well. And if we go on to the next slide, that covers that as well. What you've got to do, you've got to use plain English and tailor your terms to be relevant to your particular scenario and what's likely to arise. Give clear advice to your client as to what they can and can't do, and that, as I say, that applies to you in-house as well as to us in private practice. On employment settlement agreements, there's a separate set of rules, of course, and you know that employees have to get separate advice, that they've had all the relevant advice as to giving up their claims, etc., in an employment context. So there's that extra layer as well in the employment situation. And you just mustn't take unfair advantage. And there's a few examples there of when that would be the case, of if you browbeating someone by virtue of your position as a solicitor to sort of bounce them into something unfairly. Again, that, as you might expect, would or could be a breach. So if we just quickly go to the next slide, so that's what the SRA says in its warning notice. There's also a Law Society practice note, and that relates much more to specifically to employment-related agreements. Again, easy to find. Go and look online when you're looking at it. But that gives some useful exceptions on the duty of confidence in this sort of scenario. And so you might usually provide that, yes, of course, you can report misconduct or criminality, you can do whistleblowing, you can make your protected disclosures, you can disclose things to the tax authorities, you can disclose to close family provided they agree to keep it confidential, and so on and so forth. So have a look at that practice note for full details if you ever get involved in such things. And even if you're not employment lawyers or with a particular HR brief, I know my wife's an in-house lawyer, you'll often get involved in this sort of situation when there's a sort of sensitive departure, and it is for you, if you get brought in at that stage, to ensure that your HR colleagues and your management colleagues don't get things wrong. So just on to my last slide in conclusion, if we could, Mark. What tips can I say? I think just play it with the straightest of straight bats. It is not an area to try and be clever. It's not an area to try and sort of sneak in some protections which you're not really entitled to, because as with our case, your regulator could be looking at this at any stage, and believe you me, it is much, much better to have done it by the book when that BDI is trained upon you than not to have done it. These are serious regulatory matters, and if you do it wrong and sort of ride roughshod over individuals' rights and try to browbeat them into something that's inappropriate, that will be treated seriously. And you can't always achieve what your internal client or the business or whatever might want for good reasons. And I know no one as an in-house lawyer wants to be seen as the department which says no and is a barrier to things people want to do, but you do have your regulatory obligation, which does supersede all these other things. So unless you're at the very end of your career and you want to go out and you don't mind being struck off, I would suggest that you do this right, because this is very much on their radar. So there you are. That's all I had to say about our position as regulated individuals, and some things for you to bear in mind there. So over to the questions and so on now, I guess.
Thank you very much, gentlemen. We've got just under 10 minutes for questions. We've had a lot of questions, so we won't be able to get through all of them in this session, but where we've got details of the people who've asked the questions, we will answer your questions after the event, so bear with us. But just working through some of the questions, I will put those out. Some of them relate to individual slides, but I'll put them out there. On the question of jurisdiction, which you spoke about, Mark, are there kind of favoured jurisdictions in relation to disputes and also arbitration around NDAs?
I think that actually English law on confidence is very strong, and I'm not aware of a stronger law on the law of confidence. Most European jurisdictions now, well, all EU jurisdictions have the Trade Secrets Directive. Now, there are qualifications what amounts to a trade secret, but they're not actually a lot different to the definition of the historic sort of English common law definition of confidential information. So I think most EU jurisdictions should be relatively safe. My understanding from having been involved in cases in the States is that in the States it's much harder. There's a threshold of value which is greater to establish that something is a trade secret and should be protected. So I think as a sort of pecking order, I'd probably go English, another EU jurisdiction with an effective court system, because I think what's very important here is that the court system is effective. Without wanting to be unfair to any particular jurisdictions, I wouldn't be wanting to seek an interim injunction in some southern European territories, for instance, simply because I don't know the courts could move as quickly as I'd need them to move. Whereas in Germany, I'm pretty confident they could. And actually, I would also always say that it makes sense to have a jurisdiction which ties in with your governing law. So you're looking at jurisdiction and governing law. You want a governing law that's strong, so English, European, US, probably in that sort of pecking order. But if you're looking at jurisdiction clauses, the effectiveness of the court system is important. Simon, you may have some views on that as a litigator as well.
I'd totally endorse that, because in the vast majority of cases, if you've got a breach of confidence, as Mark said earlier, what you want is injunctive relief to stop the harm, because damages claims for breach of confidence are much less common. And with all of these, when you're putting in clauses which puts an obligation on someone, the question always come back with is, well, so what? And what if he breaches it? So some of these things is, well, we'd be a bit embarrassed, yeah, but would you have suffered any loss or damage? So you can stick whatever you want in agreement, but a breach of it doesn't necessarily give you a remedy. So particularly in the commercial situation, it is all around protecting that level of confidence. Damages aren't an adequate remedy. And as Mark says, the ability to spring into action in a court system, which will give you effective emergency relief if it's worth your while doing that, is absolutely key.
Okay. On the question of termination, is there a general preference on termination regarding the information being destroyed or returned, or does it just depend on the circumstances?
I think well, I'm not sure there's a huge difference, because if someone destroys the information, actually nowadays increasingly what you're required to do is remove it from all of their servers, every copy electronically, because most information now is stored electronically, and actually deletion and permanent deletion is the most important thing. I'm not sure there's a preference, but I do think I would, where that is going to be important, I would be looking to have a certificate signed by an officer of the recipient confirming they've complied with that obligation, because I think the most important thing is to make sure that the recipient has done its best to properly comply with that obligation, and getting someone to sign on the dotted line to say they've done so is the best way of encouraging that. Okay.
Another question. I have an ongoing quarrel with our CEO, which we may or may not be able to resolve this morning, but about information received under an NDA and whether it can be disclosed to potential investors. Is this a common issue, and is there a best practice way to deal with it?
I think it is a common issue generally as to whether information can be disclosed to third parties, where those third parties haven't been considered. My view is this: if this is information that's been disclosed under an NDA, for instance, for the purposes of a collaboration agreement, and the recipient is looking to obtain to get investment, and as part of that they're saying, look, we've got this potential collaboration agreement with Blogs and Co. That's very unlikely. It depends on the definition of purpose, but it seems to me if the purpose was that collaboration agreement, it's very unlikely that investor needs to know that information for the purpose of the collaboration. And I think, therefore, it would likely be a breach of the NDA in a circumstance like that to disclose it. So what it comes down to, again, is that definition of purpose. And I suppose as a recipient, bearing in mind when you're negotiating what the purpose is, thinking about what you really are going to want to do with that information. But if this investment is completely separate from the original purpose of the NDA, there may be a problem there disclosing it, I think. And yes, it is a common problem that parties want to discover at a later date. They want to disclose information to parties they didn't have in mind originally when the NDA was entered into. But that's what NDAs are for, is to restrict that disclosure.
And if, try and seek consent, obviously, but it might be, as Mark was saying, that the fact of the collaboration is what you want to be able to disclose, and that may not be confidential. It's just the detail of the trade secrets underlying it, which may or may not be. But you far better to get consent, because you then run the risk that you have breached it, and in any subsequent dispute, a kind of lax internal attitude to your obligations of confidence will be used by your opponent as part of its evidence for its injunction or whatever, that you were just riding roughshod, you didn't care about it. So just having enough of a paper trail to show that you were taking it seriously, you had systems, you asked the question, is always good, evidentially, even if there is a subsequent spat.
Yeah, and that's a really good general point. If you can show you've got really good internal procedures, it's going to make life much easier if you ever do get accused of breach of confidence.
Okay. We've only touched the surface on the number of questions that we had, but we are running short on time, and it's my job to make sure that we stick to the time that we said and the time that's in your diaries. So, in the next in the next minute or so, if you wanted to add your name to the question that you've asked, if you did it on an anonymous basis, and we've not been able to cover it in that Q&A session, then please do that. And we will, as I said, if we've got contact details, we will come back to the questions that we've had after the event. But Mark, if you could just flick on the slide. As I said, We are looking for ideas for our next in-house in focus, on our next in-house in focus webinars for next year. Our final one for this year is a reflection on Brexit and looking to the future on the 15th of December at 10 a.m. So please join us for that if you can. Registration will be open soon, so please look out for the invitation. And Mark, if you could just flick on to the next slide. As I said, please, as you exit today, let us have your feedback on this session, but also tell us about what topics you would like us to talk about, and we will endeavour to collate those and cover those topics over the next few months. But as it is 11:15, I would just like to say many thanks to Mark and Simon for that presentation. I hope that you found it useful, and from the long list of questions that I'm looking at, it's undoubtedly the case that you did. So thank you very much for your time this morning. Have a good day, and thank you for joining us. Goodbye.
Thanks, everyone.
Yeah,
Bye.
thank you, everybody.